Thank you very much, and thanks again to Mark Horvitz for his inspiring presentation and all the energy he brought to accessing these records. I don't know that the law is as interesting as what he had to say about these deep background checks in which you can find out. I have one of those unusual names, and if you put it in, you will probably find out as much about my background or more as compared to Mark. So what you need to know about Maine public records law is my topic. And I thought I'd start with some inspiration from some of the founders. And of course, transparent government is necessary for democracy to function, because we can't very well hold our leaders accountable without knowing what they're up to and what they're all about. And as Madison said, without popular information, we're headed toward a farce or a tragedy. John Adams also had some things to say about getting information and understanding the character and conduct of those who govern, and he referred to our rulers. Justice Brandeis, in talking about securities law, referring to securities law, said that sunshine is the best disinfectant, electric light the best policeman, and the same could be said for our public records laws. And a more recent comment by a U.S. Court of Appeals judge out of Detroit in a case involving access to public access to deportation hearings said that democracies die behind closed doors, and I think that is true. Our legislature and our right to know law included a statement of purpose, and it's a little bit more lengthy, but just as high-minded as to what the purpose and intent of our public records statute is, because in Maine, these rights are statutory rights. They're not constitutional rights. Some states, New Hampshire, for example, has a constitutional right to public records and public access. In Maine, as in most states, that right is controlled by statutes passed by our legislature. The federal courts have held that the First Amendment generally does not apply or is not a basis for compelling government to disclose information. So this statement of purpose is pretty typical of what a lot of legislatures included in their right to know laws. Our legislature included a reference to clandestine meetings that is great and is different and is unusual. It's further the intent of the legislature that clandestine meetings, conferences, or meetings held on private property without proper notice and ample opportunity for attendance by the public not be used to defeat the purpose of the subchapter. So, referring to the right to know law. So the point being that the smoky backroom dealings and meetings and so forth are subject to our right to know law. State versus federal records, and Mark touched on access to federal records. Maine law applies to Maine records. Massachusetts law applies to Massachusetts records, and so forth. Federal law applies to federal records. The scope of the law, and it's really broken into two parts: access to meetings and access to records. What I'm focusing on here is access to records. The meeting side is when is government required to have a public meeting? To what extent can the government have an executive session or a secret meeting? With regard to records, what's covered? All state legislative, executive, administrative bodies, county, local government, quasi-government, the Maine Housing Authority, the Maine Turnpike Authority are covered by the right to know law in Maine, to the same extent as any, as a city or county or the state. The right to know law does not apply to the courts or court records. The courts have taken the position that as a constitutional matter, they control access to court proceedings and court records. A number of years back, the legislature attempted to require that certain proceedings in court be televised or at least accessible by broadcast TV, and the courts sent a polite letter but firm letter to the legislature saying, thanks but no thanks. We decide what is how our hearings and court proceedings are covered. So judicial records are generally public, but they're just not controlled by the statute. Access to judicial records is controlled by the Constitution and by the common law, and in Maine there's an administrative policy on access to the courts, that generally governs access to judicial records. Access to public records, to be or not to be a public record. Everything that you can think of, you name it, it's a public record. The presumption is yes, it is always a public record, unless there's a specific exception. Anything within the possession, custody, or control of government is accessible to the public on request. Some examples, as Mark mentioned a number of examples: property records, police logs, contracts, accident reports, budgets, bids to get government contracts, salaries, expense reports, calendars, you name it. Format. Paper and printed matter, of course, when the right to know law was passed originally in the 1950s, that was primarily what we were talking about when we were talking about public records, paper. Why are the paper mills in Maine having so much trouble? Well, everything's going digital. That's all public record too. And our statute's pretty clear that the access to the record does not depend on the format. So email, public record; voicemail, instant messages; electronic data. There's a statute outside the right to know law in Title V, in the section of the Maine statutes that governs the Office of Information Technology, that says any document created or stored on a state government computer is a public record. And it refers to exceptions, so potential exceptions exceptions can still apply, but think about that. Exemptions. There are plenty of exemptions to the right to know law. Some of them make sense, some of them don't. Criminal investigations, some personnel information. We have a statute that makes 911 transcripts public, but the audio recordings are confidential. I'm not sure what the rationale for that is. Labor negotiations, medical records, tax returns, tax records, student records. Right now, legislative working papers, and I put question marks next to the governor's working papers. That remains to be seen depending on what this legislature decides to do. How to get a public record? Ask. Doesn't have to be in writing. Don't have to state a reason. Once you get the records, they can be used for any reason or no reason. Government doesn't have a right to judge whether your request is for good cause or how you intend to use the records in deciding whether to provide access. Our law doesn't give journalists any special standing to get records that's not available to anybody else, any other citizen. The only possible exception comes with regard to cost. There is a provision for waiver of request for fees if the request would contribute to the public understanding of a significant issue. But otherwise, the media doesn't have any special rights.
We do have sources.
Can you address statutory exceptions for police logs? I apologize for not having the citation, but in trying to obtain the police log, I was given by the police chief a blanket no based on a statute to protect the person's personal information, something to that effect.
That's a questionable, and that that's an illegal response. Police logs, what the law describes as original records of entry, such as police blotters that are maintained by any criminal justice agency, compiled and organized chronologically, are public record. They may be able to remove certain information from those police logs, like the names of a victim or potentially medical information or something like that, but the police blotter is a public record in Maine. And there is a specific statute that says that. Notwithstanding all the other exceptions for investigations and so forth, the police blotter is a public record. Cost, well, in general, the cost should be nominal to get a copy of a public record. A reasonable fee to cover the cost of copying. Inspection is always free. Cost should be modest. The issue with cost is that if you get it's hard to police this requirement because, if you ask for a record and it's 2 pages and they want to charge you 75 cents a page, it's $1.50. You're not going to go to court over that. It's a lot easier, and ends up being potentially easier to pay the $1.50. But in reality, cost should be governed by what you could what does the local copy shop charge, and why are you charging me $1 for this record? What's your specific statutory authorization for it? And there isn't one. What the statute says is a reasonable fee to cover the cost of copying. If the request is extensive and you're looking for years of records going back, and it's going to require them to launch some kind of internal audit or investigation and assign a bunch of clerks to dig out the records you're looking for, government can charge a search fee of $10 an hour. That may go up to $15 an hour as a result of legislation now in Augusta. But still, the cost is pretty modest. Advance payment is required or can be required if the cost is over $100. And what the courts have generally said is that an excessive fee is a constructive denial. If you ask for a public record, it doesn't do you very much good if the fee is quoted at $1 million. It might as well just be a denial. And that should be true if the fee's $1 and the cost of the copying the record is 5 cents. I mean, one of the sort of cutting edge issues around cost is, well, can I just bring in my document camera or my scanner, my portable scanner, or take a photo of the record? And that all should be allowed. That has not been tested in court. But the theory is that, look, you shouldn't be forcing the taxpayers to fund the copying, but on the flip side, this is public records generally in Maine is not a revenue generating opportunity, not a profit center for government. It's a requirement, and it's a cost center at the end of the day. It's a cost center to provide transparent government. Time, if there's a denial, 5 days, 5 working days. Right now, the statute doesn't have a firm end date on when records must be provided. Right now, the statute is a reasonable period of time, and that's because of the broad range of public records requests. A simple request, that should be fulfilled on the spot immediately. A complicated request, again, some of the Maine Housing Authority requests for years and years of contract data and so forth. Yes, that takes a while for any, that's reasonable to expect some period of time is going to be necessary to pull out that data. But there have been efforts to tighten this up, and it just hasn't been tightened up. So what if the answer is no? So ask why. You're entitled to know the specific statutory basis for denial of the request, and show me where it says that. This isn't just your policy, and in the past you haven't gotten a similar request, and we don't give that out. It's, well, show me these. Cite to me the section of the Maine Revised Statutes that says that record is confidential. And if your position is, well, that record has somebody's social security number, is fine. Take your black pen, black it out, make a photocopy, and give me the rest of the record. If there's some particular information in the record that's confidential and that can be taken out, it has to be taken out. And the courts have addressed that issue and said, look, the fact that some document contains one little piece of confidential information doesn't make the entire document confidential. Some more ideas if you get a no. Well, I'd like to talk to your supervisor. Is there a public records officer or someone who usually deals with public records? Have you talked to the Maine Municipal Association? Have you talked to town council? Can I talk to corporation council about that? Can I have your position in writing on this? This is the last suggestion is kind of a tougher one, and and I don't know that you can actually require that they provide it, but if it goes to litigation, I certainly can. Well, I want a privilege log. You're saying these records are confidential. Okay, give me a listing of the date of the record, the author of the record, and the statutory basis for withholding that record. Can you at least confirm whether there are any records that are responsive to my request? And depending on which agency you're dealing with, they might be willing to do that. The state has in the past been willing to do that. And part of the reason is, look, I'm just in good faith trying to confirm that these records are legitimately confidential. And if you're not willing to tell me anything about them, you're kind of leaving me with little choice but to see SIG and take you to court and ask a judge to look at these records. But if you can give me a little bit more information about them, maybe in good faith I'll agree that at the end of the day this stuff's confidential. Now, law enforcement is not going to give you a privilege log if there's an ongoing investigation. But if it's a personnel file, for example, or something like that, it's a good idea, worth asking. Some other ideas, if there, you know there's going to be a problem, wouldn't it be nice to know the law going in so that you're not in the position of asking them to tell you what the law is, but you're in the position to say, gee, I looked up the statute that governs your agency and it says all contracts once a bid is awarded are public record. And you, by the way, your regs say that too right here. I'd like to see that file. Makes it a little bit harder to get a no. My other thought is a lot of these records get traded between municipalities and the state. I had a situation recently, we were trying to get TIF records on a project in Westbrook, tax increment financing. A substantial tax break was going to be given to a major business. The city said, oh, those records are confidential, that's a trade secret of this business. We went and asked the state that approves these things, and the state gave us the records no problem. So, worth asking. And if you do want to appeal a denial, you've got to act pretty fast, 5 working days. But you can always ask again and restart the clock. There's nothing that prevents multiple requests for the same record. Finally, a few resources on Maine law, Maine public records law. As Mark mentioned, the Reporters Committee for the Freedom of the Press has an open government guide. It's a 50-state survey of public records and public meetings law. It allows you actually to compare Maine law with other states, and it's very, very user-friendly. I wrote the Maine chapter. The Maine Office of the Attorney General has a Freedom of Access Act webpage with an FAQ, frequently asked questions. That is accurate and useful. That web page also gives you a link to search for exceptions, and you can do a keyword search for exceptions. You can do a search for exceptions based on the title, based on section. It's not necessarily 100% accurate, but it's a great start. Maine Freedom of Information Coalition has a web page as well with lots of good information on the right to know law. The legislature established a Right to Know Advisory Committee. They've got a website, they've got reports, they've got other information on what they've been up to. Court records, check out the Judicial Branch website, and federal records, FOIA.gov. And the U.S. Department of Justice has a very good website with a free sort of treatise on the Federal Freedom of Information Act. A lot of good information there. So that's my thumbnail sketch overview of Maine public records law. Thank you very much for listening. If there are any questions.
Just one last thing. On the 5-day appeal period, appeal to whom?
Court.
Oh, okay. So
We don't have
an administrative step. We don't have a ombudsman yet. That's been proposed. The legislature hasn't adopted that or funded a position. If a records request is denied, you have the right to go to Superior Court and ask a judge to look at those records. And the usual process is, number one, the judge wants to know about the exception that's claimed. And number two, the judge is going to want to see the records in question and compare in chambers whether the records legitimately fall within that exception. And you have the right to ask a judge to undertake that review.
Prices in terms of copy, or is there anyone trying to log in and review this? For example, I go to court pretty regularly to get documents, and a 25-page document gets to your court report is $25.
Right.
I think of it 10 cents a page.
Right.
Look from the government bank, it's $1 a page. And while my newspaper may foot the bill, it doesn't hurt me personally if I were in the public domain.
Yeah, I mean, I think, as I mentioned, unfortunately, the courts have sort of said that they decide how much their records are going to cost, and they don't feel that they're bound by the right to know law, separation of powers issue. They just think the legislature can't, the separate branch of government, legislature can't tell the judicial branch how we're going to manage our records. But it's a problem. It's no question it's a problem, and there have been efforts to The Maine Freedom of Information Coalition did an audit of copy prices a number of years back, and that led to some tweaks to the legislation to try to control that. But there's no question that fees for access to records is a huge problem. There's been a litigation I'm involved in concerning access to property records, Registry of Deeds records. The registries of deeds are a huge profit center for the counties, so they've basically been generating lots of revenue to fund other completely unrelated county operations by selling copies of land records. And so an entrepreneur came forward and said, gee, these are public records. I would like them at a reasonable fee related to the cost of copying. They're all digitized in a database. I would like a copy of the database. The cost to copy a database is very small. I will buy your hard drive. I will pay for staff time to monitor the copy. Whatever the actual out-of-pocket costs are, I will pay. And the registries responded that we would be happy to provide those public records to you for the price of $25 million, because our fee is $250 a page. And this is, millions of records at $250 a page. And we took the counties to court and sued 12 counties. Ended up dropping the number. We wanted to drop the number to 3. 3 counties refused to accept our invitation to be dismissed from the case, so they stayed in. We actually had a week-long trial in Cumberland County Superior Court on the price to copy a digital database of land records. And the judge said, after hearing evidence, yeah, it doesn't cost that much. And so issued an order that should provide all the records for a few $1,000, basically. All things considered, buying a hard drive and so forth. And the counties have done 2 things. They've appealed that to the Maine Supreme Court. That's now pending. We don't have a decision yet. And they've also had their lobbyist go to the legislature, and they've convinced the legislature that they really ought to continue getting a lot of money for these copies, and the legislature is about to, and probably will, by statute, take away, exempt Registry of Deeds records from the copy fee in the right to know law. So, yes?
What is the best way for an individual not connected with a newspaper to appeal to Superior Court?
You can file an appeal pro se on your own behalf in Superior Court, and that has been done in right to know cases. There's a filing fee and so forth. It's a good idea to have an attorney, but certainly it can be done, and the judges are generally pretty solicitous of an attempt to file a case yourself. The problem is, of course, using your taxpayer funds. Your friendly neighborhood county or city government or the state, represented by the AG's office, will have lawyers, and those lawyers will throw every possible trick in the book at you to delay and deny your request. So no, it's a problem, and obviously if you're going to court, even a simple case is going to cost thousands of dollars in legal fees if you hire an attorney. A few years back, in response to efforts by the Freedom of Information Coalition, the legislature did change the law so that you can recover your attorney's fees, but you have to show bad faith, and that's a high standard. I do think, though, that there are plain and obvious cases of violations. You should be able to show bad faith and succeed, and there's some things you can do to try to set up the claim of bad faith. Gee, if you didn't realize this was a public record, let me educate you. This is a public record. Here's the statute. It's very clear, and that should be that's kind of a incentive for government to sort of straighten up and fly right if they think they may have to be not only pay their own lawyer but pay your lawyer too.
I would think, though, that it's where you just run into somebody who's just an obstruction that's been stonewalling you. If your only alternative is to incur legal costs yourself, that's effective denial, isn't it?
Yeah, it's a problem. The only other angle really is that the right to know law is enforceable by the state and by the district attorney. So the Attorney General's office or the district attorney can enforce the right to know law and pursue a violation, and they can get a civil penalty of $500 for a violation. But it's not a bad idea to start complaining to everybody you can think of, including the Attorney General's office, and at some point you may get a different answer.
If I can make one other suggestion, Sig, too, if you're just a member of the public, another way to deal with a situation like that where you feel you're being stonewalled is I would go ahead and contact the press. We're often really interested in those as stories, and perhaps in pursuing those claims, you know, and then it falls on us to pay the bill.
Right. I mean, is the AG's office really going to enforce the right to know law against, you know, the Department of Environmental Protection? Probably not.
I have a question about state legislature just approved disbanding MEA, Maine Education Association Benefits Trust, and releasing the usage of the utilization of the health care among school districts, and releasing that for bid for health insurance companies. And does that violate HIPAA, Health Information Privacy Act?
Doesn't sound like it would, because you're just talking about data. HIPAA is a whole, you know, minefield of, you know, generally, you know, medical records are exempt under the state statute as well, and I would suspect that'd be the case there. I should probably just end and say that there will be an opportunity for more questions later, and please feel free to ask any questions of me after. Thank you again.
Thanks everybody for being here today. This is great. As Rose said, I've been in journalism in Maine since 1975, and been to a lot of gatherings, but never one like this that included so many journalists, so many students, so many citizens, and at least one lawyer. I don't know if there's any other lawyers in here, but there is another lawyer here. So that's great, and that's what the First Amendment Coalition is all about, is bringing all these different interests together. I know you guys have a lot of questions, and that's what we're going to handle now. So first, I wanted to introduce Erwin Gratz, who many of you may not recognize, but you all know. And have known for a long time, because you spend a lot of time in the car with him and a lot of time in your kitchens and maybe even your bedrooms with him. So Erwin is the voice of MPBN in the morning, as many of you know. He grew up in New York City. He moved to Maine in 1978, just a few years after I did, and he worked for a dozen years in commercial radio in Sanford. And then in Portland, before beginning to freelance for MPBN in 1990. He's been the local anchor of Morning Edition since September 1992. From September 2004 to October 2005, Erwin served as national president of the Society of Professional Journalists. He holds a master's degree in journalism from New York University, and Erwin also has an interest in astronomy, which he indulges to this day as an occasional show presenter at the Southworth Planetarium, which is just a few 100 yards from here, right? Yep. Welcome, Erwin. Tony Ronzio. I don't have to say much, because I think half of you work for him. But in case you didn't know, Tony recently rejoined the Sun Media Group as director of the new media department. Sun Media Group publishes the Sun Journal, the Forecaster, which is very well represented here, and a number of other newspapers and websites around the state. Prior to rejoining Sun Media, Tony was editor and publisher of the KJ, or the Kennebec Journal, in Augusta, and of the Morning Sentinel in Waterville. He was the editorial page editor of the Sun Journal from '06 to '09. A native of Rhode Island, Tony has been working in print and online journalism in Maine since 2001. He is a graduate of Syracuse, where he earned a bachelor's degrees in magazine journalism and history, and is the former president and current treasurer and legislative affairs chairman for the Maine Press Association, where he has dealt directly with FOI law and the Journalist Shield Law. So I think we've heard from Sig, and you'll have a chance to, of course, ask more questions of Sig, but I thought I'd let Erwin and Tony give their spiels, and then you can ask questions of them, and I've got a few questions for them. I did want to say, I don't know if you mentioned it, Rose, but I saw a pile of sandwiches on the table outside here, so I hope you'll all stay afterwards for lunch. And I hope all the panelists and Mark can stay as well and chat with folks. Okay. What?
There's a mic for you, so you can join the panel.
Oh, okay. I will do that. All right. So, Erwin, why don't you go ahead?
Sure. And you guys are already getting into what I think will be most productive time for us answering questions, so I'm not going to take a lot of time. There are just a couple of thoughts I've had as I've been listening since I got here this morning. Number one, of course, Mark Horvath had all the fun information for you about all of the new interesting tools on the web. I wanted to second something that Sig mentioned during his presentation. You know, one of the things that I find about the statutes in Maine that govern the right to know laws, they're generally pretty understandable. I would strongly suggest that you take the time to give them a read. It's not too hard usually to figure out whether the law is on your side or not in a given situation. And one other thing that our statute says, and this is worth keeping in your back pocket, I think, too, the statute says that Maine's freedom of access law is meant to be construed liberally, which I always take to mean that if you're ever in a gray area, which the law is not addressed, the law is on the side of disclosure. That's what the legislature intended. And I'm not sure a lot of times you'll run into public officials who understand that, and so that may be a good thing to point out to them, and it's very easy to point out in the statute. Something to think about along those lines. Let me also point out one other group that hasn't been mentioned here a lot today, but that is interesting, and it's an interesting development in kind of the history of our right to know law statute. You know, it came to be in the late 1950s by an act of the legislature, at which time Maine was way ahead in this kind of legislating. In fact, that's 7 years before the federal Freedom of Information statute was passed. But in the decades after that, we saw the rise in exemptions, and it actually wasn't until the early part of the last decade when the legislature was convinced to actually do a survey of exemptions to the right to know law that we realized the number was actually in the hundreds. And it was in the very late 1990s, early 2000s, because we'd had a long history in Maine of seeming to fight losing battles, that we followed up on an idea that had begun to take root elsewhere, which was to expand the legislative lobbying effort beyond journalists. And yours truly called pretty much everybody he could think of and talked to them about creating a Freedom of Information Coalition in this state, and we got a really good response. And when you stop and think about the people for whom freedom of information laws are valuable in addition to journalists, it becomes very interesting. You talk about organizations like the Natural Resources Council of Maine, talk about an organization, this was one of the most enthusiastic groups, was George Smith and the Sportsmen's Alliance, which was forever having battles with the state over getting access to information for their own narrow purposes. We also found allies in the State Library Association, among the state archivists at a time, and we eventually put together the Maine Freedom of Information Coalition. The coalition has conducted two what are called audits, but are really just tests of the system. One of them was in 2002, the other one was in 2006. And they went much like these go elsewhere around the country. They proved, I think, very effective in finally getting the legislature to turn the corner. In the last 10 years, we actually have had several bills that have been pro-FOI. We don't get anywhere near as much as we'd like to see, but it's been a big change. And so as a result, they are supposed to be municipalities are supposed to be providing FOI training for their employees all the time. As Sick pointed out, there's even the possibility now that one can get legal fees back if you actually succeed in a case and there is bad faith. So, and in perhaps, I think, one of the most interesting victories that we saw, the legislature agreed to sunset all exceptions to the right to know law every 10 years, meaning the legislature has to review them and repass them. And, you know, again, the immediate impact of that has not been to lose a lot of them, but nonetheless, we finally have them under scrutiny, and they'll stop going along on automatic pilot. So all of that, I think, is useful. And the Freedom of Information Coalition is another place one can turn to if you're having issues, because they'd be interested in hearing about it, and perhaps can help direct you to resources, especially if you're just a citizen and you don't have access to, your local newspaper and its legal resources. The coalition's got a website, mfoic.org, and you can see lots more information there, including information about the results of the audits and links to the statute as well. So again, I think there's a lot more that we all can say in response to your question, so I'm going to stop there and turn it over to Tony.
Well, thank you very much, Erwin. Thank you very much, everybody, for coming. And I don't know if since so much of this audience is related to my current company, whether I'm going to face some friendly fire here today. So give it your best shot, everybody. There's nothing about FOIA I can say that Erwin or Sig can't say better. I've learned a lot from these two gentlemen over the last 4 or 5 years in my involvement in the legislative advocacy side around FOIA legislation in Maine. And the MFOIC has been a great leader in this state for getting attention to these issues and drawing together sort of these disparate coalition of interested parties together in one unified voice towards getting greater transparency in our government. My background is as a reporter and an editor, and doing FOIA requests is a lot of fun for reporters and editors because it is like a treasure hunt. However, for everybody in this room, whether you're a journalist, an attorney, an interested citizen, an activist, or just somebody who wants to know more about this, FOIAs are targeted tools to get out information. They're not blanket requests for information you think that exists. When I'm working with reporters and editors, or when I was managing my own newsroom, my first rule of issuing a FOIA was know what you're looking for and do your reporting ahead of time to make sure your request, when it comes in, is targeted at information that you know is there, documents that you know exist, and that so your chances of being denied or being delayed go down greatly if you know more about the documents than the person you're asking them from. And in two quick examples that I've worked on during my career, an editor at the Sun Journal newspaper, some of you may know her name is Judy Meyer. She's an expert in this field. When there was a fatal boat crash on Long Lake in Harrison and Naples about 3 or 4 years ago, we were able to piece together the circumstances of that crash via dispatch logs and other records and sort of these sort of pieces all put together about how an emergency is communicated among different agencies and dispatching happened. We were able to do that because of the reporting ahead of time to know how the situation happened, how the agencies that responded work together, how they communicate, what kind of documents they produce when they communicate. So by the time that the FOIA went out, it was a fait accompli. We know you've got it. Here's what we want. Here's how you're going to get it. And that information was provided. I took that same approach when I was running the Kennebec Journal newsroom, and we had reports of some hinky contracting activity in a small town outside of Augusta called Chelsea, where it was always alleged that the first select woman and her husband, who was a road contractor, were gaming the road bids a little bit to make sure they profited from everything. How do you go about and prove that? You find out everything about how that town contracts out its road projects. You look at how they do it. You discuss with town officials about what documents may exist to prove it. You talk to other contractors. You talk to everybody, and you go and you piece together what you're looking for, and you ask for that. You don't just send a blanket FOIA over there saying, hey, send me everything you got about road contracting. Because if, A, it's unspecific, it's going to take a long time, it's going to take some back and forths, it's going to take a lot longer to get at what you're looking for than if you're strategic from the very beginning. So that's the one rule I wanted to talk about here today with everybody. Do your homework first. If you do your homework on a FOIA request, you may not have to call Sig. Sig may not want to hear that, because it's his business. But I think he would agree that if the more targeted that you are, the better off your success rate. It'll also make you more knowledgeable about how your government works if you're asking the questions ahead of time. And I look forward to your questions, and I'll turn it over to Sandy.
Yeah, so, Erwin, you mentioned the liberal interpretation business regarding the right to know law and how journalists can use that to their advantage. I've had experience, too, where public officials use that to their advantage, and they said, you know, I would say, we can't have that. And said, no, but, you know, interpret it liberally. And I am interpreting it liberally, and you can't have it. That's my liberal interpretation. So I don't know if others have had those experiences, but we want to hear your war stories, hear your questions, and Mark's still there in the back of the room, and I hope he'll get involved as well. So let's have at it. Go ahead.
Russ, in the legislature, is there a central focus of opposition against freedom of information in like 1 or 2 or 3 people in terms of those who don't want it, or is it generally distributed? And if it's centrally focused, can you tell us where and who it is and whether these are campaign issues for that?
Yeah, I'm not sure how they play out as campaign issues. I mean, traditionally, a lot of times the resistance we run into is from the Maine Municipal Association, because at the end of the day, most of the requests for public records are going to municipal officials. The MMA's position, you know, very often is that these FOI statutes are a burden on municipal officials who have more important things to do in running town business. They often will tell municipal officials that there are balanced interests here, both between the public's right to know and the kind of the necessary stewardship of these important records. You know, the kind of paternal, we have to be careful with who we give these records to. And, you know, unfortunately, just as a matter of principle, you know, we disagree. I mean, these are the public's records. They don't, and the law does not say that they have to be careful about who they give these records to. If there's a citizen and they walk through the door half drunk and they say, I want to see the superintendent's contract, they're supposed to turn it over and say, here it is, have a nice day. There's the detox center down the street. You know, but that's the attitude we run into all the time. I mean, sometimes we run into other specific issues. I know you know, from time to time we cross paths with the Attorney General's office if they feel that we're encroaching too much on their ability to do investigations out of the public eye, you know, in matters that might have something to do with criminals' work. But most often our opponent is the Maine Municipal Association. And, you know, and to its credit, and you know, the legislature actually has been, I've found, in the last decade, much more receptive to some of these issues than I would have ever imagined. And I think in some cases it's just been getting the right kind of educational effort before them. And I think here the Freedom of Information Coalition has been very useful, because a lot of times when FOI bills in the past would go up before legislative committees, they tend to poo-poo them as press bills. Mm-hmm. But when we show up, along with the League of Women Voters and somebody from the Natural Resources Council and the Sportsmen's Alliance, now they've got to stop and think, wait a minute, this is not a press bill, this is about the public. And, you know, and I've seen a lot of interesting support in a lot of interesting places. You know, one of the guys who's been, I think, has generally been pretty good when these issues have come before the Judiciary Committee is David Hastings. He's a Republican state senator from Freiburg. Mm-hmm. And you know, when there was a piece of legislation that the Maine Heritage Policy Center put in last year that was actually introduced by the state Senate President, Richard Rosen, you know, that would have actually made a lot of changes in FOI law that we liked. The bill's probably not going to get passed in that form, but it was just, you almost brought tears to your eyes to listen to him stand up there and talk about the public's right to know and how important all of this stuff was. And I think one of the keys, too, is that when we go before, when these issues come up before the legislature, especially as they deal with the executive branch, and we can talk a little bit more about this in regard to the LePage bill, legislators know that they need the right to know law to be strong, or they don't get the information they need for their constituents. I'm sorry, I'm saying the legislators often realize that they need this statute to be strong, otherwise they have trouble getting information from state government for their constituents. So anyway, that gives you kind of a little bit of a lay of the land politically.
Yes.
What point does working with someone to get records and copying fees, when does the idea that this should be digitized or can be digitized, if you're seeking emails that really don't have to be put out on paper, where does that come into the idea of what they can legitimately charge for retrieval or staff time or copying fees, anything like that? And are you seeing more of this idea that some of the fees really aren't relevant or justified anymore for the way things are stored?
One of the fights that I know Sig and I have been part of is how a fee is calculated. Because the statutory definition of how a fee is calculated, Sig, is, if you can help me, is the actual cost of producing a record. Okay, well, what is that? You know, what does it, you know, for me to take an email and turn it into a PDF and then put that and email it to you, what's the actual cost of that? There's no way to calculate it. The larger problem that we see is that in times of shrinking local government revenues, and state government revenues, mostly local governments, it's the idea that records are a commodity upon which they can use to turn a profit. And that's something that which we're all fundamentally opposed. It's a public record. It should not be used to fund, the dollar you make from that should not be another police cruiser or another salary or something like that. It is something you provide, not a product that you are retailing. But it's a case-by-case basis at this point. I don't think there's any case law or anything standard that can say your fee is incorrect for that reason. We're sort of fighting on a turf battle here.
Right. I mean, I think the rule is you can't require the government to create a new record for you, but if the record exists in that format, it's a public record, and you know, if push came to shove, I am very confident that a judge would order that they provide the record in PDF if it's already in PDF, or but that's going to end up being a negotiation because, as was mentioned, a lot of government officials view the records as, you know, to be safeguarded, and that their role is to sort of guard the integrity of the record, and they don't want any, you know, third party plugging into their computer to copy the records and so forth. But the reality is, okay, you know, here's a blank CD, still in the shrink wrap, you know, still wrapped. Make a copy of the record on the CD. And the format of the record has utility. As Mark was mentioned, you know, searching for these Excel spreadsheets is very, very powerful because you get the raw data and then you can manipulate the data in any way you wish to get information rather than getting, you know, a stack of paper records. So the format really has a lot of utility in addition to the information in the record.
What we don't want is government agencies doing massive information technology investments based on the cost it takes to house a record. So your server costs for the entire city of Portland should not be factored into how much it costs to get a PDF from one office emailed to you.
Okay, yeah, in the back.
Yeah, hi, this is a question for Tony, because you brought up that situation Chelsea. There's a town in Freeport that has, in Maine, that has issues with its road contracts. And, you know, I came to that conclusion by going in and looking at the files there and seeing some issues, some questionable things. I requested, I didn't write that it was FOIA, but I put in writing a request to see documents related to that. And there was no response. So the town manager basically did not respond for some period of time. How do you deal with situations where they may say, oh, we don't have that, and they do, or, you know, if they don't want to show you what they've got, if you've identified, hey, there's an issue here, you know, I'd like to see specifically your way tickets or something, you know, some very specific thing that I outlined. And they said, you know, no response, and then basically, you know, we don't have that. You know, how do you deal with that? I mean, you know, and is the forecaster interested in reporting on that kind of thing?
There's 3 questions here. The last one is definitely yes. First of all, you don't have to say anything more in a FOIA letter than saying pursuant to Maine's Freedom of Access Act. I would like.
You know, so I sent an email that you said I'd like to see this.
Yeah.
I didn't cite the FOIA. I said I'd like to see this information.
I would just use that phrase, pursuant to Maine's Freedom of Access Act. Stop. Don't need to cite any chapter and verse, anything more than that. But that makes it an official FOIA request, and that will trigger the 5 days for denial and get the process started.
But are you asking specifically for documents? I mean, you specify what documents you're looking for.
Right, but I mean, that communicates, that language would communicate to the town or whoever you're sending it to that this is an official FOIA request. The clock has started, and you are, waiting a denial in 5 days or some kind of answer of what kind of records you can receive. But beyond all that, if you know that these records exist and they won't give them to you, you keep asking. You keep asking. Polite, civil, and stubborn, I think, is how as Sig put it in his presentation. And if you get continually stonewalled, there's the press, there's an attorney, there's, if you live in that town, there's your elected representative. I think, Sig, was it in your presentation, if not mom, ask dad. But if you know it's there, and you know that they're generating that record, and you know that record is public, they have to give it to you.
By the way, one other thing too, this, although it's of limited help, but the statute does say if they're going to deny you the record, they have to issue the denial within 5 working days. Once those 5 working days have passed, you can presume there is a record to be had. And in fact, they've essentially said that they are going to produce it. Now, when they get around to doing that, who knows? The reasonable time standard is very loose, but if they haven't said no within 5 days, they have, according to the statute, essentially committed to providing the record at some point.
Yeah. In Chelsea, it took phone call, personal visits, reminders, gentle, polite, civil reminders that, hey, I've requested this information. I'm available to come and inspect it at your convenience. I'm available this date, and this date. You let me know when you want to come in. And eventually, it worked.
I'm confused about the 5 days. In my notes, I wrote a person has 5 days after denial to appeal that, and now it's 5 days, they have to respond within 5 days.
Well, there are two things. I mean, and let's take them in sequence. The law says once you have made an official FOIA request, if their answer is going to be no, they have to tell you that within 5 days. Then once they have told you that, you have 5 days from a denial to appeal. That's the way it works.
Yeah, sure, go ahead.
This is more of a tactical question, but this happens 100% of the time in these small towns regarding police logs. That the first question I'm asked is, who are you and why do you want to know? And there may be reasons why I don't want to answer those questions. So, smile sweetly and say, surely you know you can't ask me that. But is there how do you sort of maintain the relationship with these small town police departments and not necessarily give away the farm on why you're asking?
Well, I think there just one comment is when the coalition did its audit, they had that happen plenty of times. And not only that, in one small town, this person refused to say who they were and why they wanted the record, and the police actually had a cruiser follow that person leaving the police station, like to the edge of town.
Well, in all cases,
News, of course, is the law is ultimately on your side, but you're right, that often doesn't help you in the day-to-day. So maybe, especially when it comes to things like police logs that you're going to check for routinely, maybe at some point you can go and have a sit-down session with the local police chief and talk about these issues unrelated to story, unrelated to work you're doing, to see if you can reach an understanding where he or she, sees the law roughly the way you do and sets up some process by which this all happens and go from there.
Yeah,
Well,
it's just a practical consideration. It's like,
It's hardball, where you just go in there, stand there, and say, you can't ask me that, and continue to,
that's generally happens, but it doesn't.
or it's the gentler touch where it's a conversation with the person and say, okay, I'm here, this is who I am, I'm issuing this request.
It's very. A policeman will come out from behind the bar, the window, and standing there looking up, and it's, who are you? And you know, I'm usually accustomed to answering any question, but I find it extremely intimidating and sometimes flawed.
To a suggestion that Tony made is knowing what records exist and how they're created. So in litigation, we often get into requests to talk with a record custodian about their document retention and destruction policy. It'd be interesting to see that for the local police department. What's their internal policy on retaining records and keeping records? And can we see the user manual on your computer system? And what records, what kind of reports does that generate? It may have a very helpful description of all the kinds of records that they can produce and provide to you on request very easily, and that can short circuit some of the well, we can't do that, but the Maine Chiefs of Police Association, and this is also through creative searching on in this case I didn't go past Google, puts out a model policy on right to know that's endorsed, and they have some disclaimers, but right in their model policy they say, well, perhaps desirable for the purpose of record keeping, a person requesting to inspect or copy a public records not required to provide identification or otherwise disclose to the agency or custodian of the record the person's identity or affiliation. Refusal to allow inspection or copying may not be based upon a person's declination to provide identification or to disclose the reason of the request. Section, 4B on page, whatever of the policy, and it's the same policy that also specifically says police blotters or public records. So it's nice to say, well, here's the statute, but gee, I'm just looking at the Maine Chiefs of Police Association policy. Here it is, and and I'm sure Tony would be happy to write an editorial about why they are ignoring state law and why they don't think they have to be accountable as law enforcement officers.
Paul, I think you had a question.
Can you ask for any specific file types? I mean, you also said how instead of like an Excel instead of a PDF, because the PDF for usual some things is fairly cumbersome and a lot more time to do any looking at the data. So can you ask for a specific file?
Sig said is that there's a funny line when you ask them to create something that doesn't already exist. So if they don't have data in the file type that you're asking for, I don't know if there's a statutory part of it, but it could be a little problematic.
Mark, you had something.
I was just going to say there's a couple of things you can do in that situation. One of them is you can ask for, I'm sure the law here is like it is most places, where you can ask for the information electronically, right? And so there's no way they're dealing with it as a PDF. There's no way, right? Because then they couldn't do anything with it. So it might not be Excel, but they're going to have it electronically in some form. And if you can get it that way, like if you can get it as a text file, for example, it's really easy to convert any kind of text file into a spreadsheet. And we have handouts and stuff which I would share with anybody if you wanted it. So we usually recommend that you just ask for it electronically and sort of talk to them about how they keep it. And that way, even if it's in some sort of, you'll get this pushback. Well, we have we have software that's proprietary or that you would never be able to open. Doesn't matter. Ask them to export it as text if they can. And then one quick thing, just there are free tools to take PDFs and convert them into spreadsheets that are available online. There's several of them, and they work pretty well. So while I would never just accept a PDF unless you just out of time and there's nothing else you can do, there are ways to take PDFs and turn them into spreadsheets or into text. So.
Okay, other questions? Yes.
On Facebook, we can see a trend where counselors are setting up Facebook pages as counselors, town counselors. What's that relative to? Do they have to maintain an archive of? And do they have the email addresses, the people that are friending in or submitting, are they subject to FOIA? Just the addresses, not necessarily the emails themselves, but just the list service, basically the email list.
I think it's fair to say, this is the Wild West.
A little bit.
It's why Mark is paranoid.
I think at some point, the definition of public record is anything related to public or governmental business. And so if the town has its own Facebook page, or I think some police departments even now have Facebook pages where to solicit tips and so forth, and that's a great thing. it's a good idea, but that stuff's public record too. But that is the Wild West in terms of litigation, where exactly the line is and what you can force people to disclose. And obviously, in litigation, that's come up. Can you get a court order forcing someone to cough up their user ID and password for their Facebook page? And so I would just say there's no harm in asking and pushing the point and asking for an explanation. I don't think you can get a personal Facebook page under public records law just for an elected official, but if it really starts becoming that's the official town's Facebook page, well, yeah, that stuff's public record.
If your town has 5 council members and 3 of them are in a chat room together, is that a public meeting? I don't know, and no law, no court in the land has probably ruled on that.
I say yes.
Well, you're right. Our statute doesn't define the term meeting, so that is perhaps a gray area that goes back to Irwin's comment that the statute is meant to be liberally construed, and if we're going to have a virtual meeting online, why isn't that a public meeting to the same extent as a in-person meeting? And you might go through and tell the court, well, they're doing the exact same things that they would be doing if it were live and in person.
Treasure hunt than is sort of the document hunt. If you're looking for records of activity, official government records of activity, then you have a lot more reporting resources at your fingertips to be able to say, I want this document that was created on this day because I know that's how how your business works. Email is a little more temporal. Everything of between this time and this time. It's also a little more content based. Every email that referenced this name or this issue or these 2 issues. But even then, it is a little more treasure hunt, a little more needle haystack.
Hey, Tony, didn't the Sun Journal ask for all the email of the mayor or something like that in Lewiston?
I think both councils at one point or another just went blanket and got everything to see what was in there.
All the email, and did they provide all of the contents of their email
they did.
inboxes?
They did.
I mean, in one of the cities I covered, the councilors weren't even using their city email addresses to do city business. They were using one
That doesn't matter.
AOL. I know, but I mean, the city has a measure in place to keep track of every email that comes through. This has AOL account. So if I were to ask for it,
All right, we have another
I know that on the Occupy Maine, I'm not sure my facts here, but in Occupy Maine, they were able to obtain quite a volume of emails between the Portland councilors on that very subject. Was that a problem in how they did that, or was that quite easily done? Can you tell me about that?
I'm not familiar with that either. The thing I will tell you about that is that in the second FOI audit that we did in 2006, we did a test for email communication. And we got actually a generally good response around the state. And we tested it specifically because we presume it to be a gray area in the law. I mean, the statute was written before there were emails. There's no mention of email messages anywhere in the statute, but we requested email communications from town municipal officials for a certain date, I think, and we got excellent response. So obviously, I don't think you'll have a big problem if you try that.
Yeah, it's pretty well accepted that email is a public record. Email's so great because people have these email conversations that they used to, would have occurred by telephone. So there's a record you can reconstruct in detail what happened in ways that never would have been possible.
Yeah.
But the case law is evolving, or at least the legislative attitude is evolving on it as well as the years go by. There was a case, and Sig and Irwin may remember a couple of years ago when a group FOIA'd emails from the House Speaker's office, and it dredged about a specific topic. And in that FOIA, in the FOIA request, and it was fulfilled, there was one email that was a heartfelt. It was during the same-sex marriage debate in 2009. There was one email from a citizen emailing her elected official about this issue. And at the end of the email, it had a toss-away line that said, "Oh, and vote against Tabor." And some group had FOIA'd everything that the House Speaker had about Tabor, this particular email came up. Had nothing to the total subject matter of the email had nothing to do with Tabor. It was meant to be a personal letter between a citizen and the representative. She included that keyword. A keyword triggered it to be public. It had to do with her, if I recall correctly, had to do with her sexual orientation. Very, very personal information that was outed in a very public FOIA request regarding another campaign issue. And that started a conversation of, well, what do we do in that circumstance? Because you can't just Google search emails and pop up everything that has that keyword in it. The context is important. And I don't recall exactly what happened with that discussion, but it has sort of opened eyes to sort of how where the system works and also where it gets a little bit tricky.
We have time for one more question, I think, and we had one over here.
For example, say you FOIA some information. What are the rules regarding hosting that information online for it to be open access to anybody? Is there any kind of issues or problems with that?
No, I think you have a First Amendment right to post that information online.
It's my preferred method.
Okay. Yes, Rose.
If you're new to this, say you're a citizen, not a reporter, and you just want to learn more about candidates, what would be a simple way you could do it on somebody that's been in elected office before, now in a higher office?
Could you repeat the question?
If you're a citizen, not a journalist that has a lot of experience with FOIA, and you want to just do a little research on your own on a candidate for office, what's a simple FOIA that you could do for somebody who's been in an elected position before and now running for a higher office?
Let's say it's someone running for state office and they were a local official. I would call the city clerk's office, the town clerk's office, see how they do what kind of records they keep for all the votes of the body they served on, and just FOIA how that person voted on every issue that came before them during the time period they served on that board. It's just going to be a roll call. It's going to be a roster. And use that as a starting place to see how they voted on certain issues and see and draw some conclusions from that data.
It does bring up a question that I had, and that is how these are all small resource companies, newsrooms and individuals and that sort of thing. How do you know when and how far to drill down with these candidates? We don't have the time to, the road commissioner, the candidate for road commission, how far down do we drill with that candidate, and what kinds of things do we want to find out? Do we want to find out, are we researching drunk driving records and all that bankruptcies and that sort of thing, or how far do we go?
I think your mileage will vary depending on what kind of candidates you're going after. I mean, if a road commissioner in a small town probably does not need the same level of scrutiny as a candidate for U.S. Congress. But I think, as Mark pointed out this morning, getting background on people is getting easier and easier and easier. So there's no reason not to plug the road commissioner's name into some of the resources that Mark showed us this morning and see what you come up with. You never know, especially if your town may or may not have a alleged contracting issue. I don't know. Do you guys have any good answers on that? I mean, there are high-value targets and there are low-value targets, but at least everybody should be vetted if they're going to be serving in a public office.
And the key is to just be consistent and fair. As Mark was suggesting before, pick 4 or 5 different things that you want to know about every candidate who's running for that particular office, and go ahead and do that legwork and see what happens.
Yeah, I thought that was a good point. If you're going to do it for one, do it for all.
Yeah.
Don't.
Yeah, I sort of agree with that. I think it's difficult to say to a town, well, we'd like to see everything on this candidate, and just have a one-liner public records request to sort of, you're never going to get a response. The response isn't going to be what you want. So I think it's a question of trying to have the strategy that Mark mentioned. What am I looking for? What was this person's issue? What were the issues in that community? How would that be documented? What kind of records are kept? Obviously the starting point is that community's website and what's out there already, and then trying to build from there and how you can drill down to the source documents that will verify what that person's perhaps said for their biography, or what things that person's claimed credit for doing, what in fact was their role in that bill. Were they the sponsor, or were they just somebody who happened to vote for it and now they're taking credit? I mean, so I think you know, the public records law is potentially a blunt instrument, and it should be used more surgically if you can.
Okay, with that, I think it is time for lunch, and I want to thank our panelists for an excellent discussion.